Hi there, and welcome back to another episode of Drop Dead Serious. I'm Ashleigh Banfield, and in this episode, we're recapping days 4 and 5 of the Karen Read trial. One day that gave the jury a view of the crime scene, and another day that dug deep into the digital evidence that may be a lot harder for Karen Read to explain away. If you're new to this case, or if you just need a refresher, no worries. Just go back to my previous episodes, which are linked in the show notes. Let's start with the field trip. The jury was taken on something called a jury view. And this jury view landed them right outside the house where prosecutors say Karen Read ran over John O'Keefe, her boyfriend, using her SUV. We heard about the now infamous Google search, how long to die in the cold. And actually the word how was spelled wrong. It was spelled H-O-S, like Hoss. Hoss long to die in the cold. We also heard a pitched fight over exactly what time that search was made and whether the search results were erased after the fact. And then we heard from some crash reconstruction experts from an organization called ARCCA. Karen Read is depending on these witnesses, these ARCCA witnesses, to really blow up the state's case. But they didn't testify. Instead, the ARCCA witnesses spent the time on the stand defending themselves about money and contracts and about how close they really were with the defense before they ever called themselves independent. And prosecutor Hank Brennan, he frankly lost his shit with these witnesses, especially the first one. There is so much to unpack, so let's get right into it. On day 4, the jury packed up and headed over to 34 Fairview Road in Canton, the very spot where Boston police officer John O'Keefe was found dead back in January of 2022. It's called a jury view, and it's a way for jurors to literally walk the scene themselves and not just rely on photographs and videos. But before they even got out of the bus, Special Prosecutor Hank Brennan gave them a heads up. Look, weather's different. It ain't the same as the blizzard. Conditions are different, obviously, but we still want you to get a good hard look, especially at Karen Read's Lexus SUV. Prosecutor Brennan pointed out that the entire right taillight was removed from the vehicle and told the jury really to pay attention to things like the height of the bumper and the taillight, little details that could matter big time later on. Then it was the defense's turn. The defense attorney David Yannetti told the jury that photos and videos can sometimes be deceiving, but your own eyes, those are the best computers you've got. He asked them to notice the distance from the second-story window to the front lawn, the distance from the 2 front doors, the differences between the 2 driveways, and he finished by telling the jurors to, quote, take a good look at the Lexus. While at 34 Fairview, the jury was not allowed to talk, and the lawyers, they were forbidden from explaining anything further. Jurors were only allowed to look. After the jury view wrapped up, everybody headed back to the courthouse, and that's where we got into blood alcohol evidence. Dr. Gary Fowler, who ran the lab at the Good Samaritan Hospital back in 2022, testified that Karen Read's blood alcohol level was 0.093, well over the legal limit of 0.08. But the defense went right after that number. Attorney Elizabeth Little pointed out that the test they used, a serum blood test, isn't the same as a whole blood forensic test, which is usually what's used in criminal cases. Plus, she pressed Dr. Fowler on whether he considered any of Karen's health issues, like multiple sclerosis or anemia, which could skew her blood alcohol content. Dr. Fowler admitted no, he had not factored that in. Now, does any of this really matter? I mean, honestly, maybe it does, maybe it doesn't, but Karen Read has admitted to drinking. Karen Read is on video drinking. And Karen Read has never said that she was not drinking. On the contrary, she's admitted to being pretty wasted that night. Additionally, the testing was done in the morning of the 29th, many hours after the binge drinking was over. What the professionals always do, though, is they extrapolate. They count backwards. And, they say the science is pretty good. But in the end, how accurate? How accurate is it really? The jury also heard from paramedic Jason Decker. He was the one who transported Karen to the hospital for a psychiatric evaluation. And the paramedic Decker said that Karen seemed emotional during the ambulance ride and told him that she'd been in an argument with John O'Keefe. But on cross-examination, the defense attorney, Alan Jackson, made it clear that argument had happened earlier in the day, not during the evening. And as far as late night, it was just Karen leaving voicemails, nasty voicemails for John all night long. Moving on to day 5, the Commonwealth started digging into something they say you can't argue with: digital forensics. Ian Whiffen is a digital forensics expert. He works with a company called Cellbrite, and they specialize in pulling data out of cell phones. Ian took the stand and dropped a pretty big bombshell about Google searches. According to his data, Jennifer McCabe's Google search, the misspelled one, Haas long to die in the cold, the how long to die in the cold, that happened at 6:23 and 6:24 a.m. That is 4 hours later than the defense would have you believe she typed in those words. And the defense has said all along that Jen McCabe's search was done at 2:27 a.m., a time that would put Karen Reid in the clear. But aren't digital forensics black and white? There's no gray area in your digital footprint, is there? Well, it turns out maybe. That's kind of weird, but maybe. The prosecution expert explains it this way. If you open a Google browser on your phone at, say, 2:27 a.m., and then you fall dead asleep, and you wake up at 6:23 a.m. and you start typing in that same browser, it'll register as though you made the Google search at 2:27 a.m., the time the night before that you opened the browser. But once the defense starts presenting its case, you can bet your bottom dollar that they're going to trot out their digital expert to say it does not happen that way at all. And then it's up to the jury, right? It's up to them to pick the digital nerd that they liked better or that they understood better, or maybe none of the above. Maybe all of it was so advanced and complicated, it all went over their heads and they ignore it all as a wash, because that stuff happens. And on the subject of deleting searches, which never ever sounds good to a jury, the defense says that Jen McCabe deleted only one of her Google searches that morning. And yeah, it's the big one. Haas long to die in the cold. But the Commonwealth's expert has a reason for that too. That browser data actually deletes automatically when you close a tab. And that's a lot less sinister than the defense would lead you to believe. But just wait. Just wait for when the defense expert is up to bat, because this pendulum is sure to swing once again, leaving you in limbo, wondering just what the hell actually happened out there in the snow. But the prosecutors did plant a little seed about the defense expert, and they got in a little dig on him too. They mentioned that occasionally that defense expert, a guy named Richard Green, that he occasionally has to call the prosecution expert to get help.
Can you share with us when you first became aware of the data in this case and how that came about?
Yes, it was actually one of the public relations managers at Cellbrite who reached out to me or to my team because he'd heard about this case and about the confusion regarding a timestamp and requested if we could look into it and find out what the confusion was and how we could respond to it. At that point, I contacted the investigators to get more details.
Did you learn that a consumer had called about a question relative to a report produced by the software?
Yes, there was both the troopers who had requested information about this particular artifact and also a private forensics examiner, Richard Green.
And when Richard Green reached out to your company, what specifically was the question or issue?
He reached out to the tech support team, asking basically if there's a timestamp that doesn't make sense. I need to understand what this timestamp means.
The prosecutor's digital expert, Ian Whiffen, also dug deep into John O'Keefe's phone location history. And what he found really lined right up with the Commonwealth story. John's cell phone location shows that the phone arrived at 34 Fairview Road at 12:24 a.m. and then stayed put, pretty much right near the flagpole outside the house all night. But under cross, he had to admit that phone could have taken 36 steps, and that's more than enough to reach and enter the house.
So in this entry 123156, you state that there's the start of health event, quote, 36 steps / 25 meters, correct?
Correct.
Is it accurate to say that because we're in the United States and we don't work on the metric system, that 25 meters is about 84 feet? Are you able to make that calculation?
It's approximately that, yeah.
Right. Would you accept approximately 84 feet? So as we discuss meters, we can go to feet and
Yes.
about 84
I would accept it approximately 3 times 25.
The expert even tracked the phone's battery temperature, which he says dropped from 72 degrees at 12:37 a.m. to 37 degrees by 6:14 a.m., meaning John's phone, and likely John himself, was outside in the freezing cold for hours. The jury was sent home early so that the court could hammer out some issues with Karen Reid's crash reconstruction experts, like, can those experts even testify? Dr. Daniel Wolfe and Dr. Andrew Rentschler are experts from a company called ARCCA. They were hired by the Department of Justice to perform crash reconstruction analysis. And the defense, they're using the work that those guys did for the DOJ in the defense's case. But here's the twist. Today wasn't so much about how ARCCA did their science. It was more about whether ARCCA and the defense team broke the rules and misled the court before testimony even began in the first trial. There's been a lot of back and forth between the prosecutors and the defense on just who paid who for what work and when, the feds or the defense lawyers. There's also been a lot of accusations about discovery violations. And make no mistake, ARCCA reports are critical to Karen Reid's case because this company determined in the first trial that John O'Keefe was not hit by Karen Reid's Lexus SUV. So maybe that's why the prosecutor, Hank Brennan, came out swinging against them.
Did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
And you mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring to?
No, I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you were friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
Yeah. Did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Miss Reid?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Well, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
Well, when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness.
No.
Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So, are you finished with your answer, Dr. Wolfe, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So, as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place, yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially. Again, I prescribed our standard procedure.
Why was it you were talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor.
I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that is, sign any type of contract. There could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client. I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you. On March 20th, 2022, not the 22nd, not the 24th, March 20th, 2024, did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you were going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
And at some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that relationship?
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed, and I had let him know that I had spoken to the DOJ and got clarification on moving forward.
Okay. So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case?
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case?
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Sustained.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. And when you called later that day after telling them that you had permission they could use you as witnesses, what did you talk about?
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson, in which we engaged in a conversation where I gave him more information about my background, who ARCA was as a whole. I think we even got to talk a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
It got so bad that the judge had to step in, admonishing the prosecutor multiple times, telling him to stop interrupting, stop making comments, and let the witness finish.
Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCA, my background, my education, qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made?
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation?
No, sir, and it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family, your pastimes, ARCA, but never ever talked about this case?
Objection, Your Honor.
I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So, yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That old invoice, when it's sent, ultimately comes back to ARCA. That doesn't come back to Dan Wolfe.
You reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should please.
So when did you become an advocate for the defense?
Sustained.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records. Do you typically bill clients when you're spending time talking about families?
Again, that wasn't the entirety of the conversation. I think you just briefly asked me about my family.
Oh, now it's brief. Okay. All right.
Objection, Your Honor.
No comments, please.
After you had text messages with the defense, did you delete those texts?
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here. I just don't have a habit of keeping that type of text.
So
he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
No, you didn't tell me, but you just did now. Thank you.
Objection, Your Honor.
So next question, no
Okay.
comments, Mr. Brennan.
So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question
Hold the comments, please.
my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can.
But didn't matter. The relentless drubbing continued. The prosecutor just kept hammering Dr. Wolfe, grilling him about when exactly he started working with Karen Reid's legal team and whether his opinions were shaped by defense strategy before he ever put pen to paper. When the defense was up to bat, the tone shifted palpably. Karen's lawyers made it clear these weren't just hired mouthpieces. They were impartial experts hired by the DOJ.
Was ARCA under a contract with the United States Department of Justice?
Yes, sir.
Was there a contract number assigned to that contract?
Yes.
Was there an internal number at ARCA for which all time was billed for your work on that matter in February of 2024?
Yes.
Did that contract number that began in February of 2024 ever change in ARCA?
Well, let me just clarify something real quick. So the original case, when it came in from the Department of Justice, was in the year of 2023. So when that project was opened with the Department of Justice, we assigned a project number to it. That project number from the original case with the Department of Justice remained the same all the way through the trial.
And now let's go from in the trial in June of 2024, correct?
Correct, yes.
From June of 2024 to the end of December of 2024, did that contract number ever change?
No.
To your knowledge, when you were entering time under that contract number for your work, did you understand that that time was going to be billed to that contract number with the U.S. government?
That was my assumption, yes.
Did you have, from any time in 2024, any understanding that any of your time that you were entering was to be billed to the defense team in this case?
No, sir.
But the big question now, will Judge Cannoni decide that the experts crossed the line? And if she does, will Karen Reid lose two of the most important witnesses that she's counting on to beat this case? That ruling is still hanging out there, and it could change everything. But we'll see. So that's where things stand now. I'll be back again tomorrow and every day after that, bringing you the latest twists from inside the Karen Reid courtroom. I'm Ashleigh Banfield, and thanks so much for listening. And please remember one thing. The truth isn't just serious. It's drop dead serious.